Now it's okay?
Absolutely, sir. It's just setting
Okay.
it up, and I think in about less than a minute we'll start.
So, welcome to all of you and very warm good evening.
So, so most humbly, a very warm welcome to you, sir.
And
Um,
I must be thankful to Mr. Keshav Sharma ji, who gave me this opportunity to be with you
so most humbly,
to
sir, it's very kind
discuss
of you.
about the most important topic, unwritten constitution. Here, this topic is chosen for the purpose so that we may be apprised about the unwritten part worldwide, how unwritten constitutions are there and they work. Because when we talk about unwritten part, so obviously there is a misconception that unwritten means that there is no constitution, and written means that there is a written part, but that is not there. That when we say unwritten constitution, there is nothing in the name of unwritten constitution, but there are so many ways where we may defend that we have unwritten constitutions globally. There are 3 4 countries like Israel, New Zealand, UK having unwritten constitutions. And fortunately or unfortunately, very rarely we discuss this part unwritten constitution, and we are much interested in the constitutions of our own countries where we are living as a law of land, as a current norm. Now, the question is how to understand this part. The question is of understanding, and every law student or coming from legal fraternity is aware about the unwritten constitutions and the different parts of the unwritten constitutions in the you may found uh, in a scattered way, you may say like this, but we have to form a chain to understand the unwritten part of the constitution. And there is only one document where we may go and to find out the traces of, you may say, constitution at infancy stage, and everybody is aware, Magna Carta of 1215 of UK. Now what happened when we discuss about the constitutions? So certainly when we discuss about the constitution, another another concept also comes into picture, and that is a democratic setup. Definitely, because when we discuss constitution, that means we are discussing the democratic setups. Otherwise, we had a very, you may say, references of past history where monarchy existed. So to wipe out the monarchical system, the better way is written constitution, or to some extent we may say in rare cases unwritten constitutions are also there. That is a different story. But we have to understand this part, that why Magna Carta was there, and that how many types of systems, legal systems were there in the world before this framing of constitutions globally. The first thing we must remember that there are three categories or three types: canon law, Roman law, common law. Canon law of churches entirely wiped out. Now we have Roman law and common law, and we are much interested in common law system because the edifice of Indian constitution, or the edifice of entire Indian legal system, is based upon the common law system. Every law student is aware about this. So common law system basically based upon the rights and duties orientation approach, and where we have rights and where we have duties, that means we are following the common law system. And this happened UK in the beginning of 12th century, that some revolutions were made and few rights were given by the king to the city, their citizenry, that you may get these rights and now keep quiet. And like this 200 300 years, the same game followed by the different group leaders and union leaders and other citizens of the UK in different states. And later on, they were compelled to create this UK Parliament. Later on, after 400, 450 years, they were compelled to constitute a kind of instrument so that UK Parliament may be set up. And they set up Parliament, and references are there. You may get the references on this part that uh, in the end of 17th century or beginning of 18th century, 1680 onwards, they set up their UK Parliament. Now the question is here that we were colony to the UK, and whether there is any constitution in UK or not, and what is the role of their constitution, unwritten constitution. That is very important here. If you go through website of UK Parliament, you will find the exact, sorry, you may find the number of legislations 300 years old, 400 years old. Now, what category of legislations are there in UK? We have to understand like this. As earlier I stated that their orientation is based upon rights and duties approach, or later on which converted into legal rights or legal duties. That is a different aspect to understand the legal provisions, legal part. Initially, they relied upon the legislations, and their governance is very different. Even today, they are different from other countries. And their governance is that where there is a revolution, discuss the issue and provide them their freedoms and liberties. And why Magna Carta is so much important? Because directly Magna Carta was related to the citizens of the UK directly, which touched liberty part, not freedoms. So liberty was provided by the Magna Carta initially, and later on they developed this concept by virtue of different legislations, and they provided. I'm giving you a few examples. Sexual autonomy. They have provided this autonomy, that is a kind of liberty or privacy rights. They provided to their citizens by way of different legislations. They have liberties. That's why you will find very less revolutions in UK in comparison to other countries of the world. The reason is they are more inclined towards freedoms, governance part. Their governance part is based upon freedoms, and they never provided such freedoms in comparison to liberty. They provided liberties to their citizens instead of freedoms. If we compare with other countries, if we compare this part with our country, we have provided more freedoms and less liberties. That is the difference between the UK and the Indian, you may say, legal tradition. In UK, again I am repeating, liberties are more. In India, freedoms are. That is a comparison. Or you may compare this part with any other European country. You will find their liberties were there, freedoms are less, because freedoms directly affect the governance of any country. And for governance, if we compare this part with India, India have a well documented written constitutions, and we should be very thankful to the framers of the constitution and our forefathers who drafted this well drafted constitution and provide us different freedoms and liberties. That is a different story. Here we are not discussing the Indian constitution. We are discussing the unwritten part of the constitution globally, if we consider this part. So after UK Parliament comes into existence, plethora of legislations were passed and enacted later on with the passage of time, and repealing very less legislations they provided. I wish to give you one more example so that you may understand that in UK, Human Rights Act was enacted in the year 1998. In India, Human Rights Act was enacted in the year 1993. Here you see the difference of 5 years. But when we were following the UK legal system, and when there was a mandate of UDHR to provide the basic rights and particularly human rights to their citizenry, why this part is given in UK after a span of 48 years? I think now you got this point. The reason is because they have already provided the basic amenities and rights to their citizens by virtue of their different legislations. Human rights jurisprudence or development of human rights jurisprudence is not a part of unwritten constitution or written constitution. Here, there is no question of unwritten or written part. Here we may interpret it like this. I am giving you example of if we compare this UK, take example of uh, any legislations which provide us liberties or sexual autonomy legislations or reproductive rights. When we discuss this issue with the professors of UK or any university of professors of UK, that you have unwritten constitution, what is the meaning of unwritten constitution? They stress on this part that unwritten constitution is only meant for governance. Appointment of prime minister, appointment of their ministers, appointment of their dukes, duchess for on key posts. They followed the convention in this regard, and they are following. Still, they are following the conventions, past practice, which promote monarchy instead of democratic setup. The situation is same even today after 300 and 400 years. They were interested in monarchy. They are not interested in democracy, and you may say a different kind of democracy is there, and the democracy is only with the citizens of UK. Liberty, to some extent, you may say, freedoms. That's why they are least interested in political developments. They are interested in their rights. That is the difference between a kind of culture or tradition has been set up, जिसको आप बोलते हैं constitution culture has been set up in the democratic setups entirely, and we have more than 164 democracies in the world. Only 25 to 30 countries are left out because these 164 countries have written constitutions instead of unwritten constitutions. I gave you the number is 4 where unwritten constitutions are there. Unwritten means there is no such codified or well documented single document in the name of constitution. 3-4 countries: New Zealand, Saudi Arabia, Israel, and UK. Remaining 24, 25 countries having no constitution and having no democracies. And among these 164 democratic setups, only 60% are running well in the name of governance. Others fail to provide democracies and to provide the constitutional democracy to their own citizens. So that is a debate. It requires lot of time and lot of energy to understand this part. Here, conceptually, we must know. For, I think the purpose only for this purpose this lecture is arranged so that we may be apprised or we may discuss about the unwritten constitutions. Apparently, we are discussing. We are not discussing the each and every provision or ideologies behind the written constitutions. Basically, the concept of written constitutions was not there entirely in the world, and it happens only after First World War that we thought about the independence, particularly Indian. If we go through the legal history of India, that after First World War, there was a setup of there was meetings with the there were meetings with the officials of UK and the leaders of UK to set up a kind of constitution, and we framed in the year 1935. To some extent, we were successful. For what? For what we demanded constitution? We demanded constitution that successfully we may run our countries, and our partnership was there. And later on, we have well documented, well drafted document after Second World War. Here, I wish to add one more thing, that after First World War and particularly after Second World War, there was a jolt in the whole setup that we constitute group of countries and frame UNO, and then stress on the written part to for the survival of democratic setups. That was the reason that we have written constitution. Otherwise, everything was unwritten before. If you take example of India, or you take example of Bangladesh or other colonial countries, you will find only one part and one thing, that only unwritten constitution works. There was no codification, there was no such single documented. Now, coming on the point, the main after this, a backdrop of constitutions, and I think so that now you are able to understand what I mean to convey. Coming back on this word unwritten constitution, unwritten means first that there is no such comprehensive one document in the name of constitution. Unwritten means that things are in scattered manner. Scattered documents are there. That is also a kind of unwritten. Unwritten means which is based upon your custom, usages, and past practices, which your forefathers followed and you are following. That is unwritten. Now, if we compare, so that you can understand well, we compare unwritten part with Indian constitution. Come with this part. What is how we treat unwritten constitution? Is there any kind of illegality to follow unwritten part, or unwritten means which is not codified? We have take example of any just I am giving you one example of property rights. Very important. पहले से बहुत important है from particularly after we got independence. Right to property, everybody is aware that right to property was a fundamental right. And later on converted into constitutional right. We changed the status of right to property into from fundamental to constitutional right. Some would say this status was changed in the year 1978 by virtue of 44th Amendment. And some would say, if you go deeply, that this happened in the very first amendment. Practically, it was changed in the year 1951, and theoretically stamped in the year 1978 by virtue of 44th Amendment. What I mean to convey here, I don't want to discuss the amendments because that is not our topic, related to topic. The question is only one, that can we say property rights are unwritten part? Yes, it's an unwritten part, because everything we are not able to pen down every day. It is not easy for anyone to frame a document which comprehensively is about commercial part, is about income tax part, is about your property rights, is about your marriages. I think you can now understand. I'm touching the areas which are related to the constitution written part. So unwritten part, later on, we have this land acquisition matters. We passed so many legislations, say Human Rights Act 1993. We developed women rights, we developed children's right like this. And particularly, we have done a lot of things in the name of reservation by virtue of constitutional mandate. So unwritten, written, this part, there is a tug of war, that is a constitutional part and that is a unwritten part. Now come for this part, unwritten part, how it works, how unwritten part works. Sometimes unwritten part is more effective than written part. The reason is the basis of unwritten part You may check it anywhere, everywhere, anywhere in the legislation where you will find this part. That unwritten part is based upon your practicing part. Unwritten part is based upon your customs. You have a connection with the constitution because everything, every you may say a kind of energy is given by the constitution, and you are following the constitutional mandate by framing further rules, regulations, and by making further amendments. And we reached more than 105 amendment. What is the meaning of this? 105 in the last 75 years. Amendments, major amendments. Is there any need to amend again and again and again when everything is in written form? Yes, with the passage of time, with the advent of technological device, this advancement, with the doctrine of legitimate expectation, with the development of liberal part, so many areas are there towards modern world, towards welfare state. Yes, we require amendments. Amendments, if you think and go deeply through these amendments, that is also a kind of unwritten part of constitution. Unwritten means when you go through the bare language, I'm giving you an example of 21, Article 21. Everyone is aware, very simple article, right to life and liberty. And in the last 75 years, more than 30 rights are interpreted in the name of right to life and liberty. Can we incorporate every kind of right into the bare language of the right to life and liberty? No, nobody can. We just interpreted the meaning of life. We just interpreted the meaning of liberty, that liberty includes this judgment law. And beautifully, they evolved a kind of different jurisprudence in the on the basis of UDHR and ECHR, Universal Declaration of Human Rights. For us, that is also a kind of unwritten constitution. ECHR, European Convention of Human Rights, that is also a kind of unwritten part for us in the language of constitution. Just we interpret UDHR and ECHR to clarify further that this includes this and part of liberty. Reproductive rights, can we say it's a part of liberty? Yes. Can we say bodily autonomy is a part of liberty? Yes. Right to sleep is a right? Yes. Maybe for liberty and maybe for to as a matter of life. Without sleep, nobody can survive. So when we consider written part, we have to consider unwritten part also. There are so many examples. You touch any area, take example of directive principles. We developed ourselves as a welfare state. We are towards welfare state by virtue of directive principles. We framed policies. Take example of policies, very important part for the growth and development of any country. Apart from you have legislations, apart from you have constitution, but policies are very important and nobody go through the policies, particularly law students and um, uh, my dear friends coming from legal fraternity. It works for the development of the nation, where whenever we frame the policies, every mantralaya is framing policies for the betterment of the society and for betterment of their citizens. This part is very, very important to understand in the name of unwritten part. Example of any organization, we have written constitution. पूछा जाता है ना आपका constitution क्या है? Particularly in courts, what is the Constitution of your legal firm. What is the constitution of your partnership firm? A rule book. Constitution means a rule book. How you are running your company, how you are running your. But everything is not based upon written part. As a matter of practice, habitual habits, which have been inculcated on the basis of our constitution, on the basis of our past practice, on the basis of our habits, we became a different kind of person and following all of this in total. So my version is very clear that when we adopted the concept of constitutions entirely globally, God knows next time when will be there a third world war situation is like this, maybe, but rarely happens after second world war. We are results of second world war. What we are today, we are very aware, we are very careful. Nobody is going for wars. For what? That if this time there would be war, there will be no written and there will be no unwritten constitution. Everything will be destroyed. So concept of written constitutions globally, more than 90%, except Switzerland, USA, developed countries, France, we framed our constitutions for our better. And Indian constitution is the only constitution in the world having so many articles. Everything is well explained. Everything is well explained. And when everything is well explained, that's why we have more than 448 articles, 25 parts. For what? For better governance. Globally, no one having such a beautiful constitution like us. We should be thankful to our framers. We should be thankful to our forefathers. We should be thankful to the members of drafting committee. We should be thankful to the members of this framing of constitution, particularly Dr. B.R. Ambedkar ji and Dr. Rajendra Prasad ji. Think over it. I have given you this topic with few guidelines that think over it. I think so that we are at better stage from others by virtue of this constitution. You are listening me. I can see you. With the advent of technology, no doubt, with the advancement, but somewhere we can discuss these types of issues. We have liberties, we have freedoms in this country by virtue of Indian constitution. In other countries, it is rarely happen that citizens can discuss about the freedoms. They are more inclined towards their liberties. They are not inclined towards freedoms. We are much interested in freedoms and we are enjoying our freedoms with the written part. And some freedoms, no doubt, which are, you may say, not recognized by our society, but we may enjoy those freedoms and liberties also without saying that this part is illegal or this part is unconstitutional, but we are enjoying. So when you considering this aspect of written constitutions globally or any document, you must also check the unwritten part. Unwritten part is also important, which are maybe in our blood or maybe in our veins that we are not aware We should be aware about that part, that what we are doing, how we react and how we act. Not every time according to the legal provisions, but sometimes our habits, our culture, and our culture, our habit, our language also. So that is my version about the unwritten part. I don't know whether you agree with me or not, but I have to give you the framework and the guidelines about the unwritten part of constitutions. Yes,
Um,
anything so that
Certainly,
I
sir.
may. Yes.
It's very enlightening, sir. Very enlightening, and actually, as you very rightfully said, very thought-provoking. That
Mhm.
what is the written and what is the unwritten. And I think a lot of dimensions for all lawyers who would be watching. I am certain that they would have this element of interpretation and what its role is. So, but you highlighted a lot of very important other factors also, like liberties and
I have only give you a very in a very brief manner so that you may form a kind of chain to understand the unwritten part. Equally important. This
certainly,
part
sir.
is equally important.
So I'll try to take these things through questions, whatever I've received here and there,
Yes.
whatever. So one very important thing that I feel will be very relevant for anyone who has joined us and who will be watching us so far. And I also request everyone to kindly please share your questions in the chat box. Whatever is there, we'll keep on taking. So we'll try to keep it as an interactive session.
Mhm.
So one very important question, sir, for all viewers who are there right now and also in the future as well. That so how what would, so you defined the distinction between liberties and freedoms. Can you
Mhm.
please elaborate a little by defining both and by defining the difference between them? Thank you.
There is a very thin line of demarcation between liberties and freedoms. And I have no hesitation to say about the liberties and freedoms. When we framed our constitution, in India, most of the citizens were not aware about the concept of liberties and freedoms. Everybody is aware that we were new one to the constitution and very difficult to define and understand what is liberty and what is freedom. Don't compare yourself because you know and you merge these concepts, liberties and freedoms, and sometimes it is very difficult to bifurcate them and differentiate them that this is liberty and this is freedom, particularly legally speaking. After the Maneka Gandhi decision, we have to consider 14, 19, and 21. That's the then don't ask this question. If you I say that liberty and freedoms as per the 14, 19, 21, then there is no difference. But in fact, when we discuss about the liberty, that means we are discussing on the theory, on the ideology of individualism. It is related to your body, it's your enjoyment. It may be related to your dreams, right to have a dream, right to sleep. You are not affecting others, right to laugh, right to breathe, right to take water. You are not affecting others. You are developing yourself intellectually. That is liberty. Freedom is permitted when you are enjoying your liberty but not disturbing others. Or you may say very simple, those who are, you may, in a literary language, very simple words. Everybody have bubble space. Bubble space means apart from your body having 1 foot, 2 feet, a kind of bubble space. You may enjoy in that space. You may enjoy at homes. Home is your bubble space. Your living room is your bubble space. But when you enter into the home and of others, I think so you are not able to enjoy those liberties you are enjoying at home. That may affect their liberties. When your liberties are affected other liberties, that means that is a violation of a kind of freedom of others. Second, for the sake of understanding, freedoms, this terminology may affect governance of any country. If you assemble at a square more than 10 persons, the policeman may ask you why you are assembling here. What happened? Why? Because that may affect the governance of that district, that state, that village, or that area. You may go for some criminal activity. You may create hurdle for some other persons. You may block the roads. You may like this, not in a peaceful manner. Maybe on the basis of apprehension that they may create a balwa or a riot. So liberty is very important for our intellectual development, our body development, our reproductive rights. So many things are associated. Even I can't explain here all of them. Right to forget, right to erase. These are also liberties nowadays in the digital world. These are budding concepts. Academic freedom, so many things are coming up. That is the beautification of our constitution, that we may act accordingly, we may react accordingly, we may amend accordingly, we may discuss accordingly. Yes, any other?
Absolutely, sir. So that's a very kind of you to elaborate on that. I hope that it will give a lot of context to a lot of people. So we have a question from Mr. Abhiraj Singh. Abhiraj ji, very warm welcome, and I request you to kindly ask your question.
Good evening, sir. Actually,
Good evening.
sir, I have this question. So, any country that has a written constitution, does it have any advantage in geopolitical situation than the country having oral or non-codified or unwritten constitution?
Sometimes it happens. Listen carefully. Take example of countries having no constitution, unwritten. Take example of Saudi Arabia, Israel. Best example is Israel. Sometimes unwritten constitution means that they are relying upon their past practices. They act according to situation and circumstances. And I think you are aware about the Israel factor, that they always indulge in warlike situation. They mold themselves. They are growing, no doubt. They are developing better than any other country. Maybe you may compare Israel with any developed countries like France or USA without constitution. But the edifice is very, very strong. They have very strong boundaries. They have very strong edifice about their culture and society, and they are much confident that they can run their country without constitution. Yes.
Thank you, sir.
Thank you. Thank you, sir. So, in this light, further, because obviously there's this very large domain of constitutional amendments, and you very rightfully pointed out that there have been more than 105. So where exactly is the sanctity of the constitution, so to say? How we hear a lot of people who do not know what exactly is the constitution, how exactly should they see it? That जो शब्द उसमें लिखे हैं, क्या वही शब्द जब तक दुनिया और जब तक ब्रह्मांड रहेगा तब तक वो शब्द रहेंगे, या उनको बदलने का, जैसे आपने पॉइंट आउट किया कि टाइम चेंज होता है, टेक्नोलॉजी आती है, नई चीजें आती हैं, तो फिर दैट क्रिएट्स सम स्कोप फॉर सम काइंड ऑफ चेंज. So how should people see interpretation, and how should people see amendments of constitution?
It happens since 1950 that okay, when we enacted this, we got this constitution, very good constitution in the year 1950. Within the 6 months, constitution was amended first time. Could you imagine this situation within 6 months? Very fast development was there in the name of, again I am repeating, right to property, that zamindaris were abolished. When zamindari were abolished, someone challenged the zamindari system that right to property is a fundamental right. How you can confiscate our zamindari system? By passing legislation, very simple, as per the constitutional theory. And then first amendment was there in the constitution, and that legislation was put into the, was considered as agrarian reform. Here I mean to convey one thing. 6 महीने का टाइम कितना है? What is the you may say efficacy of constitution, that you require first amendment within 6 months? So many major changes were there. It depends upon the sweet will of the citizens, sweet will of the democratic setup. We have a very good procedure for to amend the constitution where we require. If you have good number of representatives, they can amend, because we have to run the society, we have to govern the country. So it's based upon the amendments. That's why we have more than 105 amendments today. I think 106, including latest one of this. So it is not bad, and we are very flexible. We are not rigid. If we compare this situation with Israel, Israel having unwritten part, but they are so confident that their entire structure, their entire governance is based upon their past practice, past followed by their forefathers, and they are still they are following. They built up their country in a different manner. We have different castes, creeds, religions, and we are working under one umbrella. That's a very big achievement for us by virtue of constitution.
Certainly, sir. Certainly, sir. So, in lighter vein, actually, as you mentioned, 6 months it took for the first amendment, constitutional amendment, to take place. I think it took me a longer time to request you to come for this session. So, just in lighter vein. But so with respect to
When USA, just a minute, when the Constitution of USA was enacted, it took 100 years to settle USA like this. We also took time. First 25 years, if you go through the amendments, first 24th amendments, if you go through that amendments, then you realize that we settled after 1973. To follow the constitutional mandates, major jolts, major developments, major legislations were passed, major amendments, major discussion in courts, full bench or like this constitutional bench. Fundamental rights case, everybody is aware, 42nd to second amendment. From where it comes? It comes due to deliberations, due to settlement. So many things were there. Not easy. Now we are at ease. And after 20 years, at ease. Because we are growing, we are learning how to settle. ये आपको हर कंट्री के साथ मिलेगा, ये कोई नया नहीं है. I have given you example of USA, 100 years. I have given you example of UK, more than 400 years. Wars between army and civilians like this. After 18th century, they settled. And similarly, they followed the same theory for Indians. For 250 years, first 250 years, they were not in favor of any kind of written document. They ruled us without any written document. Later on, they framed some charters, regulating act for their own people, not for Indians. It was the only that after First World War, we got 1935 Constitution. When they were compelled to think over it, that we have to provide them powers, share powers with them. It is not so easy. Dhire dhire. It's a slow process. It's not a scientific formula that we may apply and we may get the results. For civil society, it may take time, maybe 50, 60, 70 years to settle them. But we should remember, along with written, also unwritten part, maybe of USA, maybe of UK, maybe of Israel, maybe of Russia. As a student, we must know that's my purpose. Any other question, any other thing
Certainly,
you
sir.
may ask?
So, sir, just some fundamental things only I want to clarify so that anyone who may be referring to this video with respect to the constitution itself, that they may get some relevance itself. So, just two questions more I have for you, sir. One
Yes.
is, so considering that you mentioned the diversity of India as well, how effective do you think, we're speaking academically and hypothetically right now, how effective
Hmm.
do you think would India have been had we also had an unwritten constitution?
Our commercial working is based upon unwritten part. Constitution is only for the purpose of governance. Constitution may be of commercial firms, constitution may be of partnership firms, legal firms, other firms, companies. They also work according to their own constitution, as well as an unwritten part, practicing part. Every country works on unwritten part. The things which are inculcated in any citizens, given by forefathers, by their caste, creed, religion, how you forget them? You are also bound to follow them. You will find different reflections in their working. But for the sake of governance, we are one. We are following our written part. Clear?
Certainly, sir. Certainly. And sir, just one final thought from you with respect to uh, how should a young lawyer or a law student or maybe a senior experienced lawyer also, obviously, sir, you can obviously advise and guide them as well. So when they look at interpretation of any particular article or any particular provision of the Constitution of India, sir, should they limit themselves that this is a sacrosanct document as it is, that there cannot be any change to it in the future? Or as sir, as ideally how I see it, because sir, there are two theories why I'm asking this question, is because there is one set of ideology which has come up today, which says that no, constitution is just the way it is, which I don't understand, because any academician or any person who has any literature background, they will know that उसमें भी कोई book होती है literary, उसमें भी कुछ updates और उसमें भी कुछ चीजें regularly साल भर साल होती है. So any young lawyer or any law student or any experienced lawyer for that matter of fact going into a constitutional court, when they have to apply their mind for uh, interpretation of any particular aspect of the constitution, should they do it liberally or should they do it know that since we have a written constitution, it has to be only with respect to what is written?
For the sake of governance, what is written, there is no such need to apply mind, except the past conventions in this regard. Say, take example of appointment of chief minister, appointment of prime ministers. We may follow the past practices, also past conventions, read with the provisions of constitution. Regarding fundamental rights, interpretation of fundamental rights, because here your body may be affected. You may take the help of international conventions, treaties in this regard, because you are going to provide very valuable right, and our honorable Supreme Court and High Courts, particularly honorable Supreme Court, did well in this on this area, and they interpreted the international instruments like UDHR and ECHR while providing rights. Take example of living relationship. Till date, there is no legislation on this part. Everybody is known. But judiciary recognized this part on what basis? On the basis of ECHR, that liberty is supreme. We may use our body like we may like. So it depends upon the that you are touching fundamental right or you are touching constitutional right. When you are touching fundamental rights, you have to be very careful. But when you are touching constitutional right, you may be mechanical on constitutional rights. That's here we are bound to follow this part. Fundamental rights, we have to interpret it. There is a message of constitution that we may also follow the fundamental rights. We should respect the rights, fundamental rights of others, but at the same time, we should be very liberal to considering every aspect of way of living of others also. That is the message of constitution. Very simple. Take it at ease. Don't get mechanical and don't get a lawman that you stress on interpretations, stress on your past practices also.
Certainly, sir. I'm absolutely certain that this will give a lot of clarity with respect to people wanting to explore constitutional jurisprudence. And
we must be acquainted with our culture, our traditions. Then we may go through the constitutional provisions or any other legal provisions of any act or legislation or any bylaws, rules. Every
sir,
time there is no need to apply the law, there is no need to implement the provision. If you consider it carefully, take it carefully, interpret it carefully, I think so. The matters are resolved, and if you guide someone properly, there is no need for any kind of litigation and any kind of asking of any legal right. I just in the last line, we have legal right based, duty based orientation, particularly in our country and Asian countries, or ruled by Britishers. The reason is because we have been ruled by Britishers for 300s. That's why we have this approach, common law system. If you compare with Roman law system, they have no such approach. They have law of obligations. Law of obligation means they are under burden to do this, that. So there is no need of any right. They are doing their job. They are under obligation. Particularly in commercial legislations, you will find under their commercial part that a party is under obligation to do this. Here the party is under a duty to do this. There is a lot of difference. There is a pressure. So duty obligation means that there is someone imbibed values, culture, and other aspects also along with your working. That is a law of obligation. So you will find the difference. There are two systems in the world, Roman and common. So what my message, last message is, consider also unwritten part, not every time written. Maybe constitution of partnership firm, maybe of company, maybe of any other entity or instrument. Any other.
so it's just, how do I say, it's just very remarkable actually how you have framed the entire session today. It's been very short, but very precise and very to the point. Anyone would definitely gain from it. Now, so since you, in your last line, you mentioned duties also. So just two lines or two words on what your thoughts are with respect to fundamental duties, both in the written as well as in the unwritten constitution, and also, sir, for all everyone who's watching, what are their duties and whether if they should do them.
Again, forget about any kind of duty, maybe moral or it's our obligation. When you consider it as an obligation, you understand well. That is my version about that. Any kind of duty, maybe moral, maybe legal, or maybe social, maybe any kind you may consider it. If you consider uh, things as an obligation that you may perform well, you are a lawyer. You have to be well on your brief. That is your duty or obligation. If you consider it as duty, your performance will be less. If you consider it as an obligation, you performed well. And most of the lawyers, 99%, are under obligation. They are not under duty. That's why we call them professionals. We call them, we may be under duty, but you are always under obligation to perform.
So obligation is taxing. Duty is easy. Duty is easy actually. Duty, you know that oh, itna se itna karna hai, aise bhi tak. But obligation is very taxing.
Very active. That's why professionals are professionals. They have some different habits. They are different peoples. They are master of their own fields. That's the reason, because they have always considered it as an obligation, even at day or at night, without considering any barish, me, किसी चीज को नहीं देखेंगे, they consider it as an obligation.
But sir, having this opportunity of learning from you, sir, this is a privilege, and I am grateful to you, and I extend gratitude to you on behalf of all of our participants. So I'll just
Thank you so much. Thank you.
That's very, very kind of you. So I'll just ask everyone once again that if there is any question that you want to ask, आपका कोई भी सवाल है, आप हिंदी में पूछना चाहें, इंग्लिश में पूछना चाहें, आप बिल्कुल कंफर्टेबली इस मोमेंट पे आप पूछ सकते हैं. Yes, Dhananjay ji, I think you have something to ask.
एक छोटा सा
Yes.
क्वेश्चन है विद रिगार्ड टू दैट एनीथिंग फॉर इंस्टेंस एनी अमेंडमेंट और एनीथिंग दैट इज न्यू व्हिच इज अनप्रेसिडेंटेड इन कॉन्स्टिट्यूशन और इन एनी लॉ then how do we see it matlab we need to draw an inference from the other parts of the legislation or it has to be drawn in the context of the practice that has
If you consider it as something is unprecedented or something unconstitutional, because constitution is our parameter, you may go and challenge that amendment.
no
We
not
have a procedure.
not in terms of for instance anything that there was a judgment of recent of Maharashtra of toppling of the government that was unprecedented with regard to the procedure and the practice by which the government was toppled. So
We have a very good balance regarding the judgments and the amendments. When you have an unprecedented amendment, you may go to Supreme Court. Everybody knows the procedure. If you have unprecedented or the judgments which is not acceptable, then you may go to Parliament and bring legislation. We have very good mechanism. In very rare cases in Indian history, there is a deadlock or tie-up between Honorable Supreme Court and Parliament. Only one or two cases. एक इलाहाबाद का है और एक आई थिंक TN Sessions आपके टाइम में हुआ था. Otherwise, there is no problem. We have very good mechanism under the Constitution of India. Procedural part, we have very good procedural part.
please.
Thank you, Dhananjay ji. So with that, any last questions? I'll just ask once again.
Yes. Yes,
Okay.
yes.
So I think we can call
It's
it.
okay now?
Yes, sir. Yes.
Thank you. Thank you.
It's just been so kind of you, sir. And how do I say it's the deepest gratitude to you.
Thank you.
On
Thank you.
behalf of all of us, all of our team, and all the participants. So we're very, very grateful to you.
Thank you. Thank you. Thank you.
Thank you so much, sir. So kind of you. So, sir, I'll end the live now.